Morning, and welcome to day 2 of the Stanford Law School Veterans Treatment Court Conference. Really appreciate you all coming out here Saturday morning, bright and early, and joining us for this important event. My name is Gabe Ledeen. I graduated from this law school in 2012. I've been practicing here in San Francisco, more recently Menlo Park since then. I'm also a Marine Corps veteran. I was an officer from 2004 to 2008, served 2 tours in Iraq. Just to give a couple of quick administrative notes before we kick off this morning's keynote address. First, most importantly, the women's restrooms are located in the basement, so down one level or up one level. Unfortunately, this building was built quite a long time ago, and they don't have women's restrooms on this floor, on the first floor. Yes, or we could just do it that way soon enough. Otherwise, there are 2 mics here for comments and questions. Please come down to the mics if you have something to say, if you have a question to ask, when appropriate during the presentations. And finally, we encourage you to utilize social media to promote this event, spread the word to your friends and networks. Tweet, use Facebook, especially use Facebook. That's my employer. Okay, so it is my distinct pleasure now to introduce our keynote speaker, Judge Jeff Ross. Judge Ross received his bachelor's degree from the University of Michigan, and then he swore off winter and came here for law school. So a great decision. Prior to joining the bench in 2009, Judge Ross was a partner at Pillsbury, Winthrop, Shaw, and Pittman, where he was a co-leader of the corporate defense, white-collar defense, and healthcare practice teams. Before joining Pillsbury, he was an attorney at Friedman, Ross, and Hirsch for over 20 years. Judge Ross is a former president of the Bar Association of San Francisco. He was a founder of the Law Academy, a partnership between the Bar Association of San Francisco and the San Francisco Unified School District, in which Mission and Balboa High School students work with lawyer mentors and are employed by San Francisco law and public interest firms, companies, and government offices. The Law Academy has dramatically increased the percentage of students who are attending 4-year colleges. As Judge Ross will mention, the San Francisco Veterans Justice Court features broad eligibility requirements, support staff for case management, and integrated and dedicated VA personnel. As he may not mention, however, it also features a truly devoted judge who works tirelessly for the veterans in his court to help them address the underlying conditions that brought them into the justice system. He's doing fantastic things there, and we are thrilled to have him here with us today. So please welcome Judge Ross.
Just more of an introduction. Good morning. Thank you. On January 22nd, 2016, a Veterans Justice Court participant read the following statement in open court. She's an African-American woman, and this is what she said. Dear drugs and alcohol, if you haven't noticed, I've kicked your ass to the left. This very brief notation is not as much for your benefit or mine, but out of an obligation to my support system. I don't feel I owe you this much of my attention, let alone all this ink and paper. After all these years, I've paid. So that's it. That's all I got to say to you about you, unless to warn you of your black-hearted, deceitful, greedy, life-destructive motives. So I've met my obligations to the group. Now your time is up. Back to my new focus, life. I've got a new love. I love life. Life has come to receive me, and at this point, make no mistake, I'm too busy loving life to miss you. And if and when the time comes when I can't or don't love life's circumstances, I'll draw strength and comfort from loving me. Crack pipe. You'll be all right, though. I leave you in the care of Mr. Amsterdam. Girl, self-hatred, pity, low self-esteem. So don't look so sad. You're in your element. My focus is on mine. Make no mistake, you lost your hold on me when you consistently held me down. Peace out, I'm going to push on. No goodbyes. No see you later. no thought to you. It's all about me. INDEPENDENT. Imagine how it felt to be on the bench, because that's actually just the first 3 minutes of what I think went on for some of people here. Jenna, I think maybe Mike were there and heard this. It went on for probably about 10 minutes. I was a lawyer for 34 years. I represented people in criminal courts, federal and state. I represented people in family law cases. I dealt with a lot of emotion in my practice, and I've been a judge for 6.5 years. I never experienced anything in my legal career as powerful, as emotionally moving as what she had to say, and she continued speaking. I read the portion that I got, which was handwritten, but she then went on extemporaneously speaking about her experiences, the challenges she had had, and she concluded by saying, I just celebrated my 48th birthday, and this is the first time I can remember being sober on my birthday. So I hope that today what I can do is to give you some of the perspective of the people who have been in our Veterans Justice Court, a glimpse into their lives. In some cases, you'll again later hear some of their words, some of the challenges that they face, and some of the challenges that our team, many of whom are here today, face as we try to grapple with the role of the veteran in the criminal justice system. To do that, I'm going to speak briefly about how what we call in San Francisco collaborative courts, drug courts, are set up, what the goals of those courts are, the roles of the parties in those courts, then go quickly through very briefly the history of our court and how it evolved and ultimately became what it is today. And then speak a little bit about the issues confronting veterans in the criminal justice system, and as I said, the challenges for those courts which are working to support veterans. And I'd like to pose some issues for discussion. I don't have answers, but I do have questions, and I hope that in the course of today we'll be able to explore some of those questions and goals for our courts. I realize this is a very diverse audience. There are people here like Justice Stratton and Judge Manley who are far more knowledgeable about this subject than I. When asked to speak, I said that I should be in the audience and they should be speaking at this time. But I do think I can bring a perspective from having evolved through the system and help you, to the extent that a Keynote's job is to just spot issues, I can do that. I went to law school, this law school, and I can spot the issues, but I really look to all of you and all of you who are working in this area to help us find more answers and more ways to serve our veterans. And then I'm going to take 2 minutes at the very end to pose the question, if we are providing these kinds of services to our veterans, why should we limit them to veterans, and why shouldn't we approach the entire criminal justice system with the same framework and the same direction? And I won't belabor that issue, but I'll pose the question. So I understand from AB 1672, which has been introduced here in California, that 30 of our 58 counties do not yet have established veterans treatment courts. I can't validate that, but that is what the legislator who's introduced that legislation in the Assembly has said. And so that means about half of our counties do have these courts and half don't. So our road to our Veterans Justice Court, as we call it, started, for me actually, I'll take 1 minute and tell you the role of media. About 7 years ago, before I became a judge, I watched a television program about a court in Texas, and it was an interview with the judge who was running a veterans court. And so when I got on the bench, the first thing that happened was one of my colleagues invited me to lunch and said, I'm here to advocate, now that you're a judge, I want to talk to you about our collaborative courts. And I said, well, I want to ask you, why don't we have a veterans court? It seems to me we should have one. And the response was, well, we've talked about it, we don't have enough veterans. Also, my first question was, how do you know you don't have enough veterans? Did anybody ask? And so when I did get assigned to the Hall of Justice, which is our criminal courts in San Francisco, we have 2 courthouses, one of the things that I did was to start working with our VJO and she was already in the jail, and she was beginning to identify the veterans who could be served in the court. And we were very lucky. We had a sheriff's department, a very progressive sheriff, and he had already clustered those people who were identified as veterans in what was called as the veterans pod. So we did have a sense that we had some people in our criminal justice system who were veterans, and we were reaching out and trying to serve them. So the first thing that some of us did was, I then had a felony arraignment and prelim department. I began, when we identified veterans, rather than just assuming we'd proceed with the preliminary hearing, what we did initially was to try to reach out and provide them with services, and then I encouraged the defense lawyer and the prosecutor to try to find alternatives to the traditional criminal justice system for these people, the argument being that they're veterans and we should use the services which are available to us because of the Veterans Administration. The next step, once we identified that issue, was to begin at a challenging time in the court's financial history, just when they were cutting back on our courts and we were terminating employees and we were terminating commissioners and we were cutting our services. It was at that very time that we identified the need to do more for veterans. And so we did have in place, and we have had for 10 years, the Community Justice Center. The Community Justice Center started as a grant to serve people in the Tenderloin. Now, you won't be surprised to hear, those of you who know San Francisco, the Tenderloin is a place where we have a large homeless population, we have a large population with mental health issues and drug addiction issues, and a large percentage of those people are veterans. And so the first step was to establish a Wednesday afternoon calendar. Judge Woods, who you see there, presided over it, and so we segregated the veterans from the community justice court population and began to treat them separately and to focus on their issues. And so that was the first step down the road towards what became the Veterans Justice Court. That court was at the Civic Center Courthouse. That courthouse is a civil courthouse for the most part. It was situated there because it is in the Tenderloin, it's in the geographic area of the Tenderloin, and because it's right next door to the Veterans Administration facility. So it was really a one-stop opportunity for people to both get services and to appear in court. The problem was it had limited jail facilities, and so the goal was to find a way to bring people who were incarcerated, who had been arrested, immediately into the Veterans Court. And so the decision was made to move the court from the Civic Center to the Hall of Justice, which is about 3/4 of a mile away, but in a different neighborhood, a similarly challenged neighborhood, but a slightly different neighborhood. And so many things changed because the Community Justice Court, of which the Veterans Calendar was a subset, was geographically bounded. The person had to either live, of course not hang out for most of these people, or commit a crime within that limited geographic area. And the decision was made to move the court and have it citywide. So anyone who was living anywhere in the city was eligible, and anyone who committed a crime anywhere in the city was eligible. So we expanded at that point, and we had to adapt the court to adjust to those broader perspectives. And I'll speak in a moment about how broad our eligibility is and how diverse our population is. But I just want to take a quick moment to talk, for those of you who are just becoming familiar with what we call collaborative or treatment courts, some of the elements of that. And the reason I'm going to do that, because I know most of you know quite a lot about this, I'm going to then later talk about some of the areas in which we have had challenges in achieving the goals that are set forth for these kinds of courts. So I guess about 25 years ago at least, the National Association of Drug Court Professionals began convening annual conferences. They're in different parts of the country. Last year it was in Virginia. This year it's in Anaheim, California. And the role of these national drug court conferences was to bring together all of the people who are working in drug courts and to begin to identify standards and to standardize the practices in these courts. And so the National Association of Drug Court Professionals first in 2013 promulgated the Adult Drug Court Best Practice Standards, and then in 2015, Volume 2, the Adult Drug Court Best Practice Standards. And they set forth the differences between, in that case, a drug court and a traditional court. Obviously, the role of the judge is very different. She or he meets with the team before going into the courtroom, discusses with the team, the participants, what their needs are, how they're doing, and that's done on a daily basis before each court session. The role of the prosecutor is different because while the prosecutor is, of course, charged with public safety, prosecutors in these courts recognize that their role is to try to address the underlying causes of the criminal conduct and to work to find a cure or treatment or a means to address it. The role of the defense lawyer, of course, is also different because a defense lawyer who understands what the role of the collaborative court is to really look holistically at their client and not just to say how quickly can I get her or him out of custody, but how can I deal with the issues that brought him or her here so that this will be one time and not a multiple series of visits to the criminal justice court and system. And of course, the key to the program is to have extraordinary caseworkers. I have some here. Jenna is here. We are really fortunate in San Francisco to have such extraordinary people. And their role is challenging because they have to work within the confines of the criminal justice system with the pressures of the prosecutor on the one hand, the defense lawyer on the other, and try to really focus on the treatment needs for the client. And then in my court, we're particularly fortunate. We have a program coordinator who preceded me in the court. She was the coordinator for the Community Justice Court, and she is now the coordinator for both that court and this. And her role is really quite overwhelming. It's developing policies and procedures, helping all of the participants to stay focused in their roles and to be knowledgeable about the various participants in the court, the clients in the court, because she actually, given the way assignments occur in many courts, including mine, the judges in the Community Justice Court change every year or two. She is a constant, and so she has that historic knowledge of how the court is operated. She has a historic knowledge of our participants. Someone can come to my court today and just say, I know her. She was in our court 5 years ago in the Community Justice Court. So that's an invaluable role and critical, I think, to a successful treatment court. And then outside of the case conferencing, and then there's the probation officer who is, of course, critical. I'm sorry, I left the probation officer out. Many of our participants are not on supervised probation, but of course, many of them are, and actually we have a representative from our court. We're very fortunate. We have a chief of adult probation who came from Santa Clara County, and we were happy to woo her way to San Francisco, has really focused on the role of collaborative courts in trying to divert people from the criminal justice system, and we're very, very grateful to Chief Karen Fletcher for that. But the other participant in this, and I want to call out both Ron Perez and Mike Hogan, who are here. They don't come to case conferencing, but they, as you'll hear, are critical to the success of our veterans, and they're the veteran mentors. These are our volunteers who have performed extraordinary feats of heroism, in my view, and quite frankly, helped to save the lives of our veterans in our court, and I'll speak more about that. So together, we work to try to address these issues. I mentioned the transition from the Community Justice Court to our court, and in that respect, we're very grateful to Dr. Diana Nickel, who is the Chief of Staff at the VA. She initiated the effort. She began contacting our presiding judge and urging us to start a Veterans Justice Court, and quite frankly, but for her initiative, I doubt the court, notwithstanding the fact that some of the judges wanted to do it, I doubt that our court would have succeeded to the point that we have. So we're grateful for that, and I think that's the key to everything I'm saying. What you'll hear throughout this hour or 45 minutes is the role of partnerships, of working together, working across disciplines, working across our initial interests and identifying the interests of the participants and finding a way to address those interests collaboratively as we try to do. So these standards set forth certain goals for the court. I've already run through some of them in terms of the role of the different team members. At the end, I'll have a slide up that will just give you the references as how to get this and get other information. But among the things that the standards suggest as being critical is that we have to identify the right population. They specifically talk about targeting high-risk and high-needs offenders, people who are addicted to illicit drugs and or alcohol, and are at substantial risk for reoffending or failing to complete a less intensive program. And one of the criteria, one of the standards that the National Drug Court Conference identifies is the importance of using an evidence-based, validated risk needs assessment tool. And they say that that is really critical to the successful functioning of a drug court. And again, I'm pointing to this now because I'll return to that later when I talk about one of the challenges we're facing in San Francisco. So these tools vary. There is a disagreement in the literature about the utility of these tools as to whether or not they really do identify and successfully identify these people, but it is a standard of the national drug courts. So the reason I'm referring to the national drug courts and their program is that 5 years ago, recognizing the need for veterans courts, the Justice for Vets program was established as a subset of this organization. And for the past 5 years, and again in Anaheim on June 1st through the 3rd, these two groups will meet together. The National Drug Court Conference and the Justice for Vets, the Veteran Treatment Court Conference, will meet together as it did last year. I attended last year for the first time, so that people attending could take classes and be involved in seminars addressing the issues that are common to people in all of these courts, but also have particular focused programs that really address the needs of veterans in particular. And so those of you, again, I'll have a slide up at the end to tell you more about the conference. For those of you who might be interested in attending, it's June 1st to June 3rd in Anaheim this year. So we as a Veterans Treatment Court obviously are trying to address the needs of drug addiction, but obviously have many other issues we have to address in terms of the co-occurring symptomatology of veterans. And again, I'll identify in the front end some of the things we'll talk about later. But one of the things that became clear to me from the conference and certainly from my work is, for those of you who are in the treatment side of this, you really couldn't be more challenged than in dealing with veterans, because we know the challenges of drug addiction, alcohol addiction, mental illness, when those co-occur. We understand that. We understand how difficult it is for anyone who is dealing with those things who's also been traumatized, because in reality, most people who are dealing with those issues have been traumatized frequently in their childhood or early life, and that has added to the complexity of dealing with them. But then we have at least 4 other factors which many of you and we in the courts are challenged by, and that is pain. Just the prevalence of pain, and whether that pain is a result of an actual trauma or just the effect of carrying your body weight in armor and in supplies and in equipment. The human body is not built to withstand the amount of pressure we put on it. If you add to that people who are actually physically injured in service, whether it was in action or in other respects, the pain that results from that poses challenges. And of course, the way we frequently deal with pain is with opioids, which then leads to its own issues. The next issue that comes with pain, anyone who's ever had it knows it results in sleep deprivation. And so, of course, when you're sleep deprived, it makes it more difficult to deal with the other issues in your life. And then when you add to that not only the mental health issues, but specifically PTSD, what we have is a cycle of co-occurring symptoms. And the challenge that we face in our court is, how do you address all of these symptoms in the context of the limited time and the limited resources that we have available? So I'll pose that issue now, and as we go through some of the people I'll be speaking about, you'll understand how we've tried to address these issues, where we feel we've succeeded, and where we feel we've been challenged and continue to be challenged. So let me talk a little bit about our court, because I think it is distinguishable from most courts in its breadth and scope. When we came to the Hall of Justice, I've already told you that we had no geographic limits, so anyone who committed an offense within San Francisco was eligible for the court. This is case conferencing in my office. I won't identify all the players, but all the roles that I've described are represented here. The first distinguishing factor is that we are not limited in any respect as to the relationship that the veteran had with the military. We don't have any restriction as to whether or not their injuries or problems are combat related. We don't have any limitation as to whether or not their veterans' benefits are full or limited, and indeed, we don't have any limitation for the nature of their discharge. We don't even have any requirement that the person be eligible for VA benefits. So we have a large contingent who do get VA benefits of some sort, but thanks to a grant, and we're very grateful for that grant, anyone who served in the military, no matter how long, is eligible to come to our court. The next factor is the only limitations on eligibility in terms of the criminal conduct. We don't take people charged with murder, attempted murder, or sexual assault. But those are the only limits. So you can see we're taking people who have a wide range of issues, whether they're drug cases or cases involving violence, and that includes domestic violence. And I'll speak about that issue in a moment, because there is some question in some communities, including some members of our own in San Francisco, as to whether or not people charged with domestic violence should or should not be included in a veterans court. And that was one of the challenges that we've addressed. One of the other things that distinguishes our court, and I didn't realize it until this week, not only do we have VJOs, but every participant in our court is paired with a case manager, and she, now it used to be he or she, and soon it's going to be he or she again, works with that participant from start to finish. They do the eligibility, they determine what the veteran needs, and then they are engaged with the veteran on a weekly basis, and they are the source of information to our court. So I just learned that in some courts, the VJO's role is to pair the veteran with services, and that is the limited role. We are really fortunate in having this ongoing relationship. And so as a result, every week what I get is a one-page report that summarizes what the veteran's treatment experiences have been in the various treatment modalities he or she's participated in, so that we can then evaluate how we have to modify, if necessary, the treatment plan to address the problems that the veteran is addressing. And so that has been critical. The other thing, again, I didn't realize how exceptional we are and how fortunate we are that, in part because of Dr. Nickel, in addition to the people who are in case conferencing, I don't think it's here, when we have our Veterans Justice Court team meetings, in which we're talking about general issues and not specifically about a particular client, we have a dedicated psychiatrist, Dr. Martin Epson, who is working with our clients on a regular basis. His schedule is overfilled, but notwithstanding that, he's available to us when we have a crisis, as we have had recently. He comes to our meetings to talk, to educate us about the services that are available, mental health services that are available to our participants, and to give us specific advice as to how to deal with the particular challenges of our veterans. And in addition to that, we have a dedicated healthcare worker, so our veterans, those who are getting veterans benefits, not only see Dr. Epson, but they see a consistent healthcare worker to deal with the physical, medical issues they're confronting. And so when I was speaking about pain, that's one of the things we're very much aware of, is the overwhelming number of our participants are dealing with medical issues, some life-threatening, which of course exacerbate the challenges in dealing with their mental health issues, their substance abuse issues, their sleep deprivation, their PTSD. And so we're fortunate in that respect as well. So let me just take you quickly through some of the other issues here. So this is a picture, we have authorization to show this to you. This is a very interesting individual. He came to our court with the usual panoply of challenges. He was a Navy SEAL for 10 years. You can imagine some of the things that he experienced in that role. He came to the court with drug addiction issues, substance abuse issues of a variety of sorts. He's fortunate, the lawyer who's depicted there is not a member of the Public Defender's Office. He is an appointed counsel. Some of our clients have appointed counsel where there was a conflict in the Public Defender's Office. He's particularly knowledgeable about how to work with people with mental health issues. And I think that's one of the things that has been key to our court, is having lawyers who really understand the difference between dealing with people who have those kinds of challenges. And I happen to have this picture, but I was very happy. He was in court on Friday, as I was, and we confirmed that he'll be graduating in May. He's done exceedingly well. But as his lawyer told me and asked me to share with you, he's in part the exception because he was well educated. He comes from a very stable family background, and all of that background was really helpful to him when he dealt with the challenges that his veteran service confronted him with. And so, that's one of the benefits that he had that's not available to most of the participants in our court. The other thing that I would say about him, standing next to him is one of our VJOs. We lost her to Cleveland. Her husband's a football coach, and we lost him to the Cleveland Browns. He was here at Stanford, so it's a triple loss for us because we love Mackie. Stanford lost him, and she really was a terrific participant in this. But that's the other key thing: the role that she played and that all of our VJOs play in the lives and the care and treatment of our veterans, has been critical to their success. So this is the eligibility. I mentioned it. I'm just putting it up. I won't read it all for you, but you can see the range of misdemeanor issues. These are the ones that are only eligible upon a grant of probation. And I should say one thing. These eligibility requirements were established before I was assigned to the court, so I had no role in creating them. I was told, this is the court you're going to run, and the PD and the DA have already, public defender and the district attorney have agreed on these eligibility requirements. So they felt, and you can, I'm sure, divine why, that people who had drunk driving offenses should not be eligible unless they were on a grant of probation. The same is true of the others, including misdemeanor domestic violence. That was identified as an acceptable criteria for participation even before I got to the court. Demonstration cases, not sure why that's there, elder abuse, crimes involving children, and gun cases. So these misdemeanors are eligible, but only upon a grant of probation. All other misdemeanors are eligible pre-plea, which means that upon the completion of the court, the charge is dismissed. There is an exception. Someone who has 3 or more open misdemeanor charges, the DA has to approve their participation. For felonies, those of you who are not familiar, 1170H is a relatively recent statute that was enacted to deal with prison overcrowding. Many offenses that would otherwise be felonies eligible for state prison sentences. We now have what we call state prison sentences, which are served locally in our county jails to deal with the state prison overcrowding. Those are offenses under 1170H, and that criteria was used to say that offenses that are eligible for sentencing under Penal Code Section 1170H, that's felonies, can also be accepted on a pre-plea basis. So a lot of the drug offenses, which when convicted are served, even if it's a prison term, it's a county prison term, those offenses are accepted on a pre-plea basis. And again, other felonies except for sexual assault and murder are accepted on a post-plea. And what that means is this: where it would otherwise be a state prison sentence, the felony assistant district attorney and the felony defense lawyer, be it a public defender or private counsel, must work outside of our court to try to reach an agreed upon disposition, which would include participation in the Veterans Court. I don't participate in that negotiation, but what we do is the person is on 2 paths. So the moment somebody is identified, presumably at arraignment, as having served in the military, we ask that they put them on our calendar so that we can begin the task of determining what benefits they're entitled to and what treatment and services would be appropriate and whether they're interested in that. So we travel on the treatment path, and we actually have people who are in treatment in our court for weeks while the felony lawyers are trying to work on a disposition. And the goal is twofold. First, that will get them into treatment immediately rather than having them wait. And we even have people that are released into treatment programs before the disposition has been agreed to. And of course, the other is that by demonstrating to the district attorney that the person is succeeding in treatment, cases which might marginally fall on the side of, no, we can't agree to a non-state prison sentence, we can sometimes persuade the district attorney to give the person a chance, with the recognition if the person fails, there's always the possibility of sending them to state prison. So the treatment modality is helpful both because of its immediacy, but also because it can help prompt a disposition which might not otherwise have been available. And our last tool is that the judge who helped me get this program started and was actually in the forefront of persuading the powers that be that we needed the program happens to be our felony disposition judge. So if we can't accomplish it here, we send the DA and the public defender to Judge Collins, who then will frequently use his influence to get the person into our court. So we use every means possible to maximize our population. So I'm going to speak, let me just move this. Last. One of the things we're trying to do, however, is we don't always have the dispositions within 6 weeks. The goal is to have the disposition agreed upon within 6 weeks of treatment. So the legal dispositions available, a dismissal which terminates the court jurisdiction. Sometimes we have DEJs where the person can then withdraw the plea upon completion so they don't end up with a conviction. We do allow, in certain cases, people to reduce the length of their probation, so the people who have to participate on probation can either reduce it. It can sometimes be terminated at the end of their participation in our court upon graduation. In other cases where it's more serious and they still have some amount of time of probation that hasn't been satisfied, we let them work off a month for a month so they can stay on as a volunteer, and for every month of successful participation in our court, they can work off a month of their probation. So one of the benefits is we worked with our traffic department to get the fines and fees that were outstanding or outstanding infraction cases dismissed. We give them a gift card. We have felonies that I can sometimes reduce to misdemeanors. As I said, the infractions can be dismissed. I mentioned reduction of time on probation and early termination, and then sealing of records. So let me speak for a moment about a couple of people and how critical the role of various team members has been in their success. When I came to the court in January of 2015, one of the identified stars of the court, I'll call him Veteran P, he had full veteran benefits. He had been charged with assault with a deadly weapon. He was doing so well that in an article, a newspaper article about the court, he was identified as our star veteran. He was succeeding. He was close to graduation. Between April and December, he had had near perfect scores. We give people a score of 0, 5, or 10, depending on their success. Veteran P I've checked his record, it was a near perfect score. And when I came to the court, I thought he was one of our success stories. And then he had a psychotic break. We lost track of him. He was hospitalized out of state. He was dealing with a wide range of mental health issues. And he will tell you, and I believe this, that he would not be alive today but for the role of the veteran mentors. And Ron is here, I think he can attest to that. They reached out to him, they got in contact with him, they talked to him, and they literally, he was hospitalized in a mental health hospital. He was on a 14-day hold, and they actually talked him back into court. And he came back to court, and we gradually moved him from being in custody into residential treatment. And then in June of 2015, I had the pleasure of graduating him from the court. So in that 6 months, he went from being a high-functioning, very successful person to someone who was on the brink of suicide, and then came back to that point. And then a couple of months ago, unexpectedly, we showed up in court, but on Veteran P, and he confirmed everything I just told you, that he was distraught. He was having issues with his former wife over his children, and he was dealing with family court issues in another court, and he really was at the end of his rope and was seriously suicidal. So that's a success that I clearly attribute not just to our team, but the role of the veteran mentors, because but for their engagement, we would have lost touch with him. And so he and I are grateful to them for that. Another example, a veteran came to our court. He was identified to me as having the worst case of post-traumatic stress disorder that the psychiatrist had seen at the VA. He had been in active duty in the Navy. He had been dealing with munitions and explosives. He was 100% service-connected for PTSD. He had TBI. you'd think he'd be the perfect candidate for our court. There was only one problem. He had an out-of-state probation violation from a state in the Southwest. And although we otherwise wanted him to participate, there was a warrant, so I couldn't release him from my court, and the only alternative was to send him back to that court and have him deal with that relatively minor case. I think it was a drug case. It was relatively minor, but we had no power over that. And literally, he was about to leave when team members got a desperate email from our VJO, from Ken Miller, saying, "You can't let this happen. You can't let the sheriff's deputies put him on a bus and send him back to the Southwest. His PTSD is such that this will be a disaster." But we didn't know what we could do. But we started making contacts. So the DA contacted the DA in that county. The public defender contacted the defense lawyer. I shouldn't say this on the record. I contacted the judge, thinking that that was the logical thing to do. We do that in California, so I contacted the judge. Everybody in this southwestern state was happy to help. And what they did is they put the matter on calendar down there, and with a relatively short period of time, we got agreement from the judge, the district attorney, and the defense lawyer that this person could stay in San Francisco, that the warrant would be lifted so that he could get treatment. The reason for my comment was the judge and I learned afterwards that the interstate compact on warrants prohibited me from talking to him. And I'll just take 1 second and tell you that the way we resolved this was when it went up to the top person from that state and from our state, the agreement was this: if the judge and the judges there and I and the judges in San Francisco would take a remedial course on the interstate compact warrant, they would lift the warrant. This is true. So of course all the judges in my court, sure, will take the class. The warrant was lifted. He was in treatment. He is doing remarkably well. But for the VJO's persistence, we all would have followed the law, and he would have gone back to that state. I doubt he would have gotten there in good condition. I know he wouldn't be in a situation he is now, and he's another graduate. So again, it's the team working together that allows us to have these successes. But we don't always have successes, and we don't always have the ability to achieve our goals. And so Mike and Jenna and I and Ron know that we have been dealing with a very, very difficult case for the past few weeks. A veteran B is a West Point grad. He was an officer. When I referred to him in court using his title, he told me not to. He didn't want to be identified in that way. He was in the Army from 2001 to 2008. He was in both Afghanistan and Iraq. He has a bipolar disorder and serious PTSD. My courtroom deputy would often, when he wasn't in court, would see him, as he said, ghost dancing down 6th Street. He was a person who you would immediately identify as a scary person and someone you did not want to be around. But his crime was to make some oral threats to family members who understood his problem. His issue was he came to visit California. He's from Alaska, and what he wanted to do was to go back to Alaska. And how could we get him there? And again, a remarkable example of collaboration. The DA agreed with the support of the family to drop the charges if he pled to a misdemeanor, which was unusual because they were felony charges. We all agreed that what we would do is try to get him back to Alaska, but we had to get him stabilized because he had to get on a plane. Well, that's where the challenge occurred, because although he had been 5150 involuntarily treated, he was not, at the time that we were dealing with him, eligible for that care. And so the challenge was, what do we do? Where do we keep him while we stabilize him so that he is able to get on an airplane? And there were really no alternatives. We were told that the PICU up at Fort Miley was full. He could come up there. He could apply to get in, but in all likelihood, they would turn him away. There was no logical place for him to go to ensure that he'd get his medication or to get the care that he needed. And I'd say my worst day on the bench, I think those who are around will confirm that, I had no alternative but to remand him to custody. And he hadn't done anything wrong. There was no reason to put him in jail but for the fact that he needed to be contained so that he didn't do something that would interrupt our plan to take him back to Alaska. And so very reluctantly, I remanded him to custody. Much to my delight and surprise, our jail health team got him in treatment, and actually he was doing much better. But that was a short-term solution because he still wasn't eligible and in need of the veteran's inpatient care. He had, because of his conduct, not any criminal conduct, he had lost the opportunity to stay in the residential treatment program that he was in. And now the question was, well, now what do we do? He needs to go back to Alaska. I can't put him on a plane in this condition because I expect somewhere between arriving at the airport and getting on the plane or on the plane, he would do something that would get people really frightened. What do we do? And here's another hero. We put our heads together and everyone said, well, maybe a family member can take him. And the answer was, yeah, but not until the end of May. And what was he going to do between now and the end of May? And Ron Perez said, you know, he's trying to go to Alaska. Mike Hogan has family in Alaska. So we got on the phone with Mike and we said, feel like going to Alaska? And he said, sure. So on Monday morning, Jenna is going to pick up veteran B at his home. They're going to escort him to the airport. Mike is going to fly with him to Alaska, deposit him there in the care of his friends. He'll start getting treatment the next day in Alaska at the VA, and then Mike will come home. So thank you for that. What I'm trying to point out is that the only way these programs work is with everybody working together. But let's talk about some of the challenges, and I can do this, I think, in the time that's left, because all I'm going to do is highlight the issues, and then we can discuss how they can be addressed. I mentioned to you that the drug court standards talk about using a risk needs assessment, these tools which are a series of interview questions and static evaluation of the person's record, and that putting that information together, people are put into a quadrant as to how high their risk of offending and not succeeding in treatment is, and how high their needs are, and then based upon that, you're supposed to come up with a treatment plan. Well, this is to the VA participants. One of the challenges that I have as a judge is, in order to do that assessment, you have to have both access to the person's criminal history and you have to have access to the person. You have to be able to interview them to do a complete risk needs assessment. In San Francisco, although we're trying to enact this approach in all of our collaborative courts, the Veterans Justice Officers, the VJOs, are specifically precluded by the VA from doing the criminal risk assessment because there's literature to support this. So I'm not quarreling with the decision, I'm just posing the problem, that it's not a particularly useful tool for clinical treatment, and therefore that's not something that they should be doing. On the flip side, our probation department said, we'll do the risk assessment for you, but the problem there is the defense lawyers, and actually the DA agrees, it's not appropriate for someone who is pre-plea, which all of our veterans are, to be talking about their offense because they have a Fifth Amendment privilege, and when they talk to law enforcement, they are talking about their offense. So the clinicians can't do it, the probation department can't do it, and the Veterans Administration does not have one standardized needs assessment. In other words, different VJOs are using different, presumably appropriate, but all different needs assessments, and they're not doing risk assessments at all. So I, as a judge who's trying to follow these standards, and the people who gave us our grant are here, they know I'm doing my best to try to comply with all the standards, but it's an impossible situation. So one of the things we should be talking about is, if we think that risk needs assessments are an essential part of a treatment court such as ours, we have to find someone who can actually perform them. Because the other challenge, even if we got agreement that the probation officer could do it, then a veteran who is at his most critical stage is both having to be interviewed by a clinician on the clinical side and a probation officer on the legal side. So that is just more pressure than he or she should have to endure. So that's one issue. The second issue, domestic violence. There is controversy as to whether or not someone who has been convicted of domestic violence should be in a treatment court. The voice of our domestic violence victims community is very energized in San Francisco. I think that's really important. It's a critical part of our criminal justice system, but the argument should be that just because they're veterans, they shouldn't be coddled when they're guilty of domestic violence. We've worked through that. We have had a number of successful participants who are doing the 52-week domestic violence classes, which are required in California for anybody who is convicted of a domestic violence offense. What we have agreed is no veteran is being coddled who has a domestic violence offense. Quite the contrary. They have to do everything they would do in criminal court, and then they have to comply with all the requirements of our Veterans Treatment Court. So we are using treatment to address the causes of the violent conduct and requiring them to do everything that they would have to do if they were simply in our other court. And I could talk more at the lunch break if people want to discuss that issue. For me, I had Judge Manley to thank for the fact that I didn't know how to work through that problem when I first was assigned to this court. I knew we had to include these people, but I knew I was getting opposition, and Judge Manley was extremely helpful in helping me work through that issue. The next, this is a quick one. It's in the weeds for sure, but I think critical. I talked about the Anaheim program. That's a program where everybody involved in these courts is getting together to talk about these issues. And yet, last year in Virginia and this year in Anaheim, for the most part, our Veterans Administration was unable to pay to send our VJOs to this training. So we're all at the training. We're all talking about the issues. We're meeting. We're going to classes, and then we're having breakout sessions, and then we're having dinner and lunch to talk about what we've learned to try to integrate into our court. But the people who, in my view, are the most important people to have at these so that we can gain from their clinical knowledge and incorporate into our court are not being given the ability to attend. I understand this year a couple of people will be attending, but I think the VA needs to think about that. If the VA, which was the impetus of starting our court, believes these courts are critical, then the VA has to find a way to train and allow us to learn from the VJOs who are in our courts. Because it's clear, it's a lost opportunity for them and for us, for them not to participate. Next, one of the recommended requirements here and the requirement of my grant is that we do monitoring and evaluation. And we are collecting, we have a database of information about our participants, but we don't yet have a means for doing studies to see what has happened. And so if you think about it, we're in the worst of all worlds because we graduate people. We will find out about those people who come back because they will show up in the criminal justice system, but we don't yet have a way of tracking our success. Because if someone actually is treated and doesn't re-enter the criminal justice system, as of right now, we have no way of knowing that and adding that to our database going forward so that when we get the funds, which we don't now have, for any kind of an evaluation, I don't know how we'll get the data. So one suggestion I have, and if people have others, I'd love them, I'm going to just ask that we start collecting people's email addresses upon graduation and ask if they would be available. And then I thought what we could do is do some follow-on studies and just stay in touch with them through email and find out how they're doing on a regular basis so that we can then get forwarding addresses. Because it seems to me, thanks to social media, Facebook, and everyone else, that probably electronic information will be the best way for us to maintain the relationship so that we can evaluate that. Now, I realize I didn't time this speech, and I have 5 minutes to talk about what I think are the three most important things for us to focus on. The first, I've spoken quickly, I'm from New York, that's what we do, about the interrelationship between co-occurring pain, substance abuse addiction, mental illness, sleep deprivation. How do we treat all these issues? And one of my concerns is, are we doing enough? Is the VA doing enough? Are we generally doing enough to address pain through means other than opioids? Because there are alternative therapies, there are other ways to deal with that. I can't speak to whether the VA doctors are doing all of these things, but I know I'm seeing that people who come to court and say, Judge, you don't understand. I'm using marijuana because it's the only thing that helps me with my pain. And so a quick word about marijuana. From the classes that I've taken, my understanding is that the literature suggests that marijuana is contraindicated for PTSD. Now there's a fallacy among the veteran population. I don't know whether it's because it's just accessible here in California. I live in the Haight, anybody can get a medical marijuana card, and very soon we may have recreational marijuana here in California. But there is a fallacy that marijuana is a good thing. We know that marijuana is not regulated, so we don't know how strong it is when people are using it. It's not being supervised. The doctor who was giving them the medical marijuana cards is, for the most part, not the doctor who's treating them for other things. It's someone, again, on Haight Street, who got $50 for the card. So I'm very concerned that people think that marijuana is appropriate, and I'm very concerned, and I'm in the awkward position of not being the doctor, but saying, I know you have a medical marijuana card, but I want you to talk to Dr. Epson or someone else about whether marijuana is really indicated or contraindicated for your PTSD or your other issues. Next, I'm confident that everybody here will accept this proposition. The men and women who enter our military, for the most part, do not enter as violent individuals. They enter as law-abiding citizens. They are trained that the stimulus, to respond to stimulus in a violent manner for both self-preservation and to do their job. They go through basic training. They go through years of experience in which inculcated into them, necessarily, is that a violent reaction, a hair-trigger violent reaction, is critical to their survival and that of their comrades and for them to do their job. And we spend all of this time preparing them and re-educating them from their civilian norms and conduct, behavior, and morals into a new way of thinking. And I have a question for the Department of Defense. Are we spending as much time and effort trying to re-educate them before we bring them back into society? Because if you look at all of the reinforcement for violent conduct, and then you have inadequate time to re-educate people before they leave the military, is it any surprise that we have the suicide rates, the domestic violence rates, and the other violent conduct that we have? The stimuli are present, the reaction is swift, the outcomes bring people into my court. That's my first question. My second question, because I don't know that the DOD is here, the VA is here. If the DOD isn't going to do it, can the Veterans Administration do more? I don't use the word proactively. It's the only one that I can use in the next 30 seconds to get through this. Can the VA do more to help educate those people? Because my understanding of the military mentality is, I can get through this, I'm tough, I can do this, and a disinclination to recognize the effects that your military service has had upon you. And if that's the case, we need to take more of an effort to say to people, you've been through hell, you do need this program. I'm not saying you're going to do anything wrong with it, you've done anything wrong, but you need this program. And the second part of that, and I think equally important, is, does the VA have programs for the spouses, partners, parents, and children of these people to help educate them that the man or woman who comes home is not the man or woman they were born to, married to, in love with, or bore, if it's a parent, because parents are being subjected to hell. And how do we train them for two purposes? One, how do we train them that the triggers that they had in their prior relationship will be different now, that the responses to those triggers will be different, they may be violent? How do we help them support the veteran? And how do we help them protect themselves? How do we help them identify the fact that things are escalating? This is not the situation that was even a day or before. How do we help them to identify what's happening so that they can get to a place of safety for themselves and their children if that's necessary? So again, my question to the VA is, what are you doing, and can you do more with regard to that issue? And this is when I want to take a step back. And again, I think everybody in this room, I hope, agrees that we need to provide these services for our veterans. And a couple of questions have been asked me, well, why should we do it for our veterans? And my answer, it was asked to me last night, because we can. I mean, the reason that we do what we do in San Francisco for the veterans who have VA benefits is they have VA benefits, so we can provide those benefits. The reason we do it for people who've been in the military who don't have VA benefits is we have a grant. Thank you. We can do it. We can give them those services. So then my question is not, why do we do it for the veterans and the people who serve in the military? Why don't we do it for everyone? And I want to just posit a thought for you. The people in the military, for the most part, come from more or less intact families. They have more or less family support. They are fully formed adults. They are frequently well educated, or at least educated to some extent, because we have a wide range of veterans. They come into the military, they have this experience, and some of them leave with post-traumatic stress disorder. The 7-year-old who lives in the Bayview Hunters Point or in East Palo Alto, who may come from a family that's completely fractured, maybe living with foster parents, maybe living with grandparents, is 7 years old. His brain is not formed at all. He's a child. He sees his brother shot. He sees family members shot. He sees bullets whizzing by him as he's in his living room. Does anyone think that that PTSD is really different? I do. I think it's much worse. I mean, because all of the psychological strength that a military person has, and the training and the support from the Veterans Administration when they get out, and the military when it is in, is completely lacking in this person. Now that person ends up in my court too, because 4 days a week I do felony trials. I do murder trials, I do other kinds of trials. And yet many of the men, and they are largely African American in San Francisco, who appear in my court, no doubt have post-traumatic stress disorder, which is only distinguishable from the veterans in terms of its early onset and its severity. And so my question is, don't we need to start recognizing this? And in San Francisco, we now have a young adult court where we're treating people who are, I think it's 18 to 22, recognizing that their experiences may very well be in need of the same kind of treatment we're giving our veterans. I'm over by 2 minutes, I apologize. Thank you.
Hope to continue this conversation over the rest of the day. Our next event's at 10:30, so we have about a 10-minute break. And let's get back here.
I have one offer. I went way over. I have one thing. If anybody wants to stay for 4 minutes, you don't have to. Our court was the subject of a. Can you roll it? Our court was the subject of a PBS NewsHour special in February, and it was 8 minutes long. 4 minutes of it, is the voice of one of our veterans, and I told you to hear the voice of some of our veterans. Feel free to take your break, but if anybody wants to stay in about maybe 5 minutes, we'll just play that 4 minutes. I think it's quite telling and quite moving. So we'll have it ready, and take your break, but anybody wants to stay? Anybody wants to? All right. Is that okay? Can we just roll it? All right.
The number of veterans with post-traumatic stress disorder, PTSD, continues to grow. And as some get into trouble with the law, special veterans courts are finding different ways to deal with them. NewsHour special correspondent Spencer Michaels reports.
Remain seated and come to order. Department 4 is now in session.
Every Friday afternoon, Judge Jeffrey Ross turns his San Francisco courtroom into a veterans court, one of 220 such courts in the country that hear cases of former military members who have been arrested, often for drug offenses, sometimes for violence. To signal how different his court is, he often brings a basket of fruit and candy for the defendants.
Even me being in anger management, what good is that? Because I snapped.
It's what's called a collaborative court, where the judge, the district attorney, the public defender, the probation officer, and the U.S. Department of Veterans Affairs work together to treat or to punish each defendant.
It's good to see you. How are you?
I'm doing excellent, sir.
That's what I hear. Yes. I'm glad to hear it.
43-year-old Axel Rodriguez has had a lot of problems common to vets. He served in the Army in the Gulf War in Iraq and Kuwait more than 20 years ago.
It was crazy. It was exciting. It was scary. I have nightmares. I don't like being in closed rooms. I don't like large groups of people. I just don't feel in control.
You obviously got into some kind of trouble. You're in court.
Yes.
What kind of trouble?
I got arrested for possession of a stolen vehicle and possession of a controlled substance.
Just that one?
No, a couple times, a couple times. And at first, I didn't want to accept that I needed help.
Rodriguez spent some time in jail and kept reoffending.
Why are you abusing? Do you revert back to your time in the Gulf War and PTSD, or is it something else?
No, well, it starts off with that, but then once you become an addict, everything goes out the window. The only thing that you care about is maintaining your inebriated state.
On a few occasions, he says, he became violent.
You're talking about fights? You're talking about girlfriends?
Well, not with girlfriends, but with other men. It's just like, the combativeness. It's a great characteristic to have if you're in the military, but it's not one to have when you're out in the normal world, to be combative.
Using federal grants as well as local funds, courts rely on the VA to coordinate physical and mental care plus weekly court dates for vets in trouble. It's up to the vet to comply.
We often meet with the veteran when they're in custody to develop a plan for where they're going to go when they're coming out, especially if they're homeless.
Kyung Yi works for the VA.
We also link them immediately with mental health and medical services. A lot of folks we will put into transitional housing, or if they have a substance abuse issue, we will put them in residential treatment.
As with many vets, housing has been a problem for Rodriguez. He recently moved to a recovery house called Fresh Start, mostly for veterans, after getting evicted from another program. He claims he's been clean and sober for 8 months, and he credits the Veterans Court for helping him find new housing and putting him on a new path. He has frequent court-mandated appointments with a psychiatrist.
I couldn't open up to my own family because they used to mistreat me emotionally.
And with a nurse practitioner.
So what's been going on?
Well, I got kicked out of that program for something that I didn't do. Suspicion of being under the influence of alcohol, which I don't drink.
Every week, the key staff at the VA Center in downtown San Francisco meets to discuss the offenders.
I think there's some inconsistent taking of his meds.
And in Judge Ross's chambers, another group, including the judge, the prosecutor, the public defender, and the probation officer, collaborate on how they'll handle each vet who comes before the court.
He is doing extremely well. He's in full compliance.
There's one sentence about Axel. Here's another example. This is from February of 2015. The road got really rocky between then and now. He was a star. We picked him for this program. He had many, many challenges. He's graduating next month. So he was here. He didn't quite get down to here, but it was a challenge, but he's back up and he's there. So I think that's the secret, is you just have to stay with people and they will ultimately succeed, and Axel is. So thank you very much. Thanks for saying.